complaint charging him with murder, carrying a firearm without a license, aggravated assault and battery with a dangerous weapon, possession of a firearm without an FID card, and armed assault to murder a person over 60. Subsequent offense, a plea of not guilty will be entered.
This is a preliminary matter. I indicated to my brother that I have no objection to a present status of held without bail pending our next continuance date, at which time the counsel situation will be straightened out by whether or not he'll be able to retain other counsel, or whether or not I will continue as his counsel in this matter.
All right. Thank you.
Your Honor, Thomas Flanagan for the Commonwealth, for the record. The Commonwealth has filed with the court today a motion for a protective order on discovery, which I would ask the court to act on today prior to the end of our proceedings. I would also point out to the court, for the record, that yesterday, upon the issuance of the arrest warrant for murder against Michael Gonsolves, that Judge Dawley allowed a motion to impound that arrest warrant affidavit. And I would agree that certainly counsel should be able to receive the representation of the defendant a copy of that arrest warrant affidavit. I would ask that Your Honor consider those two issues together, the protective order and the impoundment of that affidavit. I would ask, Judge, that the defendant be held without bail on this murder and related charges complaint. As an overview of the case, Judge, the defendant is charged here with the October 11th, 2006 shooting of Shaian Colon and Rosando Marcelino here in Brockton. The shooting took place on that day around approximately 1 a.m. The victims were seated inside of a van in the driveway at 249 Green Street, and the investigation revealed in witness interviews and crime scene investigation that the van was then approached from the rear passenger side. An individual identified by eyewitness identification statements and alleged admissions of the defendant, Michael Gonsolves. Michael Gonsolves was that person who was dressed in a black hoodie, approached up the rear passenger side towards the front of the van, then produced a firearm and pointed that inside of the front passenger window. Shaian Colon, the murder victim, was seated in that front passenger seat of the van. He sustained 2 gunshot wounds when the defendant opened fire, and in fact, the crime scene investigation corroborated eyewitness statements of this scenario in recovering 4 9mm shell casings from outside of the van and 2 9mm shell casings from inside the van, thus corroborating witness accounts that the firearm was actually inserted into the van at the time that the defendant is alleged to have opened fire. The second victim in this case, which is Rosando Marcelino, is the subject of the aggravated assault and battery by means of a dangerous weapon with firearm charge, Judge, and that is based on a serious bodily injury theory of aggravated ADW. Mr. Marcelino survived the shooting. He sustained a gunshot wound to the chest, as well as a gunshot wound to the abdomen in the same attack. And while he survived, he is paralyzed from the waist down. He has provided information to police investigators. And in the course of the investigation, Judge, ultimately it was determined that a third person, Nelson Correa, who was seated in the rear seat of that van, was not shot and was completely uninjured during this incident, made statements identifying the defendant, Michael Gonsolves, as the shooter to multiple civilian witnesses. This information was expressed by Mr. Correa within days of the murder of Shaian Colon and the serious injuring of Mr. Marcelino, according to one civilian eyewitness who provided this important identification evidence. Mr. Correa had advised them that he had seen the facial area of the shooter, had walked up to that front passenger seat just feet away from him as he sat in the passenger side rear seat of the van, that he looked up from that short distance, and looking at that face, he believed it to be Michael Gonsolves. This information regarding eyewitness identification of the defendant as the shooter was corroborated by a second civilian witness, who corroborated that, in fact, Mr. Correa had provided a similar statement, a more definitive, approximately several days after the shooting in October 2006, in which he stated to that witness, I saw who the shooter was, and it was Mikey Gonsolves. The investigation of this matter, Your Honor, has gone on over the last total of 4 years until the warrant for the defendant's arrest for murder was issued yesterday afternoon out of this court. The investigation was reinvigorated in recent months with additional witness testimony. Some witnesses were completely new witnesses that had not come forward in the past. Others provided more additional details than what they had originally revealed to police. And essentially what we had in this case, Judge, was a series of civilian witnesses independent of each other coming forward and providing evidence and statements of the defendant making admissions to having murdered Shaian Colon that night. And specifically, he made statements to one civilian witness indicating that he hadn't meant to shoot Shaian Colon. He was trying to shoot somebody else when he went to 249 Green Street that night. But he went on to state, but fuck it, he got what he got. Everybody's going to die. Another witness described on the night of the shooting, the defendant had gone to the address of a mutual friend of this witness and Michael Gonsolves. Was observed in these late night hours to be pacing back and forth and appearing, in the witness's words, amped up. And Mr. Gonsolves was then alleged to have stated that night, I just went over to Green Street and aired them out. This was a phrase which the witness knew from the streets as being that he had just done a shooting. And with regard to that final civilian witness describing recently admissions of the defendant, this witness described receiving telephone calls beginning in the days after the murder of Shaian Colon, in which the defendant admitted that he had done it, but that he warned her, I got one, and I got another one in a chair. If you snitch, I'm going to kill you and kill your kids. This information was revealed to the police investigators, as well as additional statements in which statements pertaining to a motive in this shooting were made allegedly by the defendant to this witness, in which it was described that the defendant said he was angry that his cousin, Shaian Gonsolves, had been shot at on Vine Street. This motive statement allegedly made by the defendant was corroborated during the investigation, Judge, because in fact, 6 days prior to the October 11, 2006 murder of Shaian Colon, a cousin of the defendant's name, Shaian Gonsolves, was in fact shot at 42 Vine Street by one Admiral DeRosa. Admiral DeRosa, in fact, is now serving a state prison sentence after having pled guilty to committing that shooting. Admiral DeRosa, the investigation revealed, is also known as a close associate of Nelson Correa, the backseat passenger in the van, as well as a close associate of Placido Pereira, who lived on the night of the shooting at 249 Green Street, where the defendant is alleged to have crept up on the van and opened fire on the occupants. So I suggest to the court that, based on those nature and circumstances of this most recent murder alleged to have been committed by the defendant, Your Honor is aware he also has a second murder that charges are pending out against him in this court for allegedly murdering Manuel Rodriguez here in the city of Brockton in February 2010. I suggest to the court that it is appropriate under all these circumstances to hold the defendant without bail on this case as well, as he already is on the original arraignment on the Manuel Rodriguez homicide back in October 2010. And I'd also ask Your Honor to consider the filings of the Commonwealth, my affidavit, and my motion for a protective order on discovery. What I'm asking the court to do by this protective order, I suggest the court is narrowly tailored, and it's a reasonable request to allow the Commonwealth to maintain the confidentiality of the addresses of 4 specified civilian witnesses that I've named in my motion. And furthermore, Judge, that pending further order in this court, that counsel may receive the case documents, including the documents reciting the names of these individuals, but that he alone should retain these documents to ensure that they are not distributed or passed along so they can become tools of intimidation in this case, and particularly in light of the nature of Mr. Gonsolves' February 2010 murder allegation, in which he's alleged to have specifically targeted the victim in that case for murder because he was a witness in a murder case against one of Mr. Gonsolves' friends. These witnesses.
The motion requests the restriction to pertain to counsel and a designated defense investigator.
That's correct, and I believe, Judge, as I stated, I believe this is a narrowly tailored request, and it does allow counsel to work within a defense team as well on this case, but that, again, to retain the documents specifically to himself and his defense investigator, and that he can share the information about the case with his client. In fact, in the presence of counsel and the investigator, he can review the documents even, but they must be collected again by defense counsel and the investigator to make sure these don't get distributed, Judge. But actually to allow that motion for protective order. And in allowing that, Judge, I have a copy of the arrest warrant affidavit in this case, in which a address of one of the 4 named civilian witnesses in the motion has been redacted out. I'm happy to provide that to counsel today with that protective order in place, along with other discovery in the case.
And Mr. Moses, pursuant to our discussions and your representations, at this time there would be no objection to holding the defendant without bail, given the uncertainty status of counsel. That present order would be set without prejudice. Likewise, the motion regarding the protective order will be allowed at this time, again without prejudice, until the issue of counsel has been resolved. Obviously, the defendant is entitled to counsel of his choosing, whether or not he has the means to make those arrangements, or whether the Committee for Public Counsel Services would be in a position to make those arrangements for him. It is not a matter for today. Mr. Moses, your motion for funds is allowed, as is the motion for the production of scientific tests and statements of the defendant. They don't in any way impinge on the Commonwealth's concerns regarding confidentiality and witness location. And will be held without bail pending the next case.
The Gonsolves case will be continued for probable cause until January 13th, and you'll be held without bail.